Welcome to literary and jury charge practice. We'll start out with some jury charge. Ready? Here we go. The parties have agreed to certain facts that have been read to you. You should therefore treat these facts as having been proved. A deposition is the sworn testimony of a witness taken before trial. The witness is placed under oath to tell the truth, and lawyers for each party may ask questions. The questions and answers are recorded. When a person is unavailable to testify at trial, the deposition of that person may be used at the trial. You should consider deposition testimony presented to you in court in lieu of live testimony insofar as possible, in the same way as if the witness had been present to testify. The evidence that a witness has lied under oath may be considered, along with all other evidence, in deciding whether or not to believe the witness and how much weight to give to the testimony of the witness, and for no other purpose. Some witnesses, because of education or experience, are permitted to state opinions and the reasons for those opinions. Opinion testimony should be judged just like any other testimony. You may accept it or reject it and give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. When you begin your deliberations, you should elect one member of the jury as your presiding juror. That person will preside over the deliberations and speak for you here in court. You will then discuss the case with your fellow jurors to reach agreement if you can do so. Your verdict must be unanimous. Each of you must decide the case for yourself, but you should do so only after you have considered all of the evidence, discussed it fully with the other jurors, and listened to the views of your fellow jurors. Do not hesitate to change your opinion if the discussion persuades you that you should. Do not come to a decision simply because other jurors think it is right. It is important that you attempt to reach a unanimous verdict, but of course only if each of you can do so after having made your own individual decision. Do not change an honest belief about the weight and effect of the evidence simply to reach a verdict. Certain charts and summaries not received in evidence have been shown to you in order to help explain the contents of books, records, documents, or other evidence in the case. They are not themselves evidence of or proof of any facts. If they do not correctly reflect the facts or figures shown by the evidence in the case, you should disregard these charts and summaries and determine the facts from the underlying evidence. If it becomes necessary during your deliberations to communicate with me, you may send a note through the bailiff signed by your presiding juror or by one or more members of the jury. No member of the jury should ever attempt to communicate with me except by a signed writing. I will communicate with any member of the jury on anything concerning the case only in writing or here in open court. If you send out a question, I will consult with the parties before answering it, which may take some time. You may continue your deliberations while waiting for the answer to any question. Remember that you are not to tell anyone, including me, how the jury stands, numerically or otherwise, until after you have reached a unanimous verdict or have been discharged. Do not disclose any vote count in any note to the court. A verdict form has been prepared for you. After you have reached unanimous agreement on a verdict, your presiding juror will fill in the form that has been given to you, sign and date it, and advise the court that you are ready to return to the courtroom. All parties are equal before the law, and a corporation or joint venture is entitled to the same fair and conscientious consideration by you as any party. Under the law, a corporation is considered to be a person. It can only act through its employees, agents, directors, or officers. Therefore, a corporation is responsible for the acts of its employees, agents, directors, and officers performed within the scope of authority. Copyright is the exclusive right to copy. This right to copy includes the exclusive rights to 1. Authorize or make additional copies or otherwise reproduce the copyrighted work in phonorecords. 2. Recast, transform, adapt the work that is prepare derivative works based upon the copyrighted work. 3. Distribute sound recordings of the copyrighted work to the public by sale or other transfer of ownership. Or 4. Perform publicly a copyrighted musical work. It is the owner of a copyright who may exercise these exclusive rights to copy. The term owner includes the author of the work or a person who has acquired the copyright as an heir of the author. In general, copyright law protects against production, distribution, and performance of substantially similar copies of the owner's copyrighted work without the owner's permission. An owner may enforce these rights to exclude others in an action for copyright infringement. Right, now let's try some literary practice. This is called urbane SUVs. Ready? Here we go. Americans love their sport utility vehicles. In recent months, SUVs have shown the greatest sales growth among various types of cars. Says one auto industry insider, it's an SUV feeding frenzy. The SUV moniker covers a lot of ground. However, besides varying widely in physical size from compact to huge, SUVs differ in degrees of ruggedness. The Ford Expedition, Mercedes-Benz G-Wagon, or Nissan Xterra are well suited to conquering a rock-strewn trail or hauling a 5,000-pound wakeboarding boat, for example. But the three stylish mid-size SUVs reviewed here, the Ford Edge, Mercedes-Benz GLC, and Nissan Murano, are best suited to on-pavement people hauling, whether that means commuting to work or carrying kids to soccer practice. The Edge was redesigned from wheels to roof, as Ford folks say, for 2015. Based on a platform shared with Ford's popular Fusion sedan, the second-generation Edge has a new edgier exterior, a roomier interior, and new engines. A massive grille and high belt line give the latest Edge a decidedly hunky look. Inside, the theme is spaciousness, in particular the back seat, where legroom is nearly limo-like. There's plenty of cargo room too, even with the rear seat backs raised. Those rear seat backs also recline for better passenger comfort. As with most modern Fords, the cabin is attractively trimmed with high-quality materials. The Edge comes with a non-turbo V6 and an EcoBoost turbo 4-cylinder with more horsepower than the previous version. The Edge Sport Edition comes only with a new twin-turbo V6. It's a real sweetheart of an engine, providing gobs of instant acceleration. The sport's steering is quick and the brakes are powerful. Too bad its firmer suspension delivers an unsettled ride, even on relatively smooth surfaces. A 4-cylinder Edge SE may be the better choice and certainly is more economical, with a base price of $29,595 or $31,090 with all-wheel drive. All right, now let's try this closing argument. Some material from this closing argument. Excuse me. Ready? Here we go. It's enough that when he intentionally shot the victim, it was an act whose natural consequences were dangerous to human life. He knew it would be dangerous to her life, and he acted with conscious disregard for her life. The way sometimes I illustrate it would be, let's say somebody goes to like the mall or the fairgrounds during fair time, and he's got a loaded gun, and he just closed his eyes, spins around, starts shooting the gun. He's not specifically intending to kill anybody. He's doing it because he thinks it would be fun to see them scatter. And if he ends up hitting somebody with a bullet and killing them, he would be guilty of murder. He would be guilty on second-degree murder because on the grounds that he did this implied malice. He knows it was dangerous. He shoots the people anyway. Malice aforethought does not require hatred or ill will toward the victim. It's a mental state that must be formed before the act that causes death is committed. Now, that's not an issue here, since the act of shooting her shows the defendant formed the mental state of malice before he acted. It does not require deliberation or the passage of any particular period of time. In other words, even if the defendant decided on a spur of the moment to shoot his wife, he still acted with malice aforethought. Now, once we've proven it's second-degree murder, now we look, do we have facts that make it first-degree murder? The defendant, according to the jury instruction, Calcrim 521, the defendant is guilty of first-degree murder if the people have proved that he acted willfully, deliberately, and with premeditation. Now, the defendant acted willfully if he intended to kill, and clearly he did in this case based on his conduct. The defendant acted deliberately if he carefully weighed the considerations for and against his choice, and knowing the consequences, decided to kill. Now, the fact that the defendant shot his wife 3 days before their divorce would have become final indicates he did so with premeditation and deliberation. So first degree is willful, deliberate, premeditated. Again, it's a financial motive combined with the timing. 3 days before the divorce would become final, which shows a willful, deliberate, premeditated murder. Therefore, it is first degree murder, and you should fill out verdict form 1A, guilty of first degree murder, and leave the other forms blank. All right, back to some literary practice. This is called In the Know About CPOs. CPO is a certified pre-owned car, in case you were wondering. Ready? Here we go. In the Know About CPOs is a certified pre-owned car worth its extra cost. Automaker hoopla touting certified pre-owned CPO programs would make you think CPO cars are worth the extra bucks. Take the wheel with confidence, says General Motors. Unlimited peace of mind, says Mercedes-Benz. Unlimited, not quite. A CPO designation promises first that a used car has a virtuous past, including proper maintenance and an absence of significant problems, and second, that a warranty will ensure against problems in the car's future. But CPO programs don't always live up to these promises. To put some flesh on the bones, there are no industry standards. The parameters of CPO programs are set by each automaker and vary widely. Examples: Cadillac requires vehicles to be 4 years or less in age, with fewer than 50,000 miles. Porsche's rule is 8 years or less and under 100,000 miles. There is little automaker oversight, despite comprehensive inspection protocols proscribed by an automaker. The dealer decides if a car qualifies for CPO status. I've seen dealers sell cars as CPOs when their own records show they failed inspection, says La Jolla attorney John Hansen. Any dealer can self-certify. A used car lot, for example, a dealer unaffiliated with an automaker, can come up with its own inspection program and label its cars as certified. Warranties differ. A CPO warranty rarely provides the same coverage as the original factory bumper-to-bumper warranty. For instance, BMW's CPO warranty excludes such things as certain suspension components. And as you say, there is a cost to the consumer for CPO designation from several hundred to several $1,000, often as much as $3,000 to $6,000. So is the whole CPO thing marketing rubbish? Not at all. If the car was properly vetted and the warranty is meaningful, which requires some homework on your part. First, carefully study the terms of the CPO warranty to see that it meets your expectations. Most automakers provide the terms on their websites. Also study the Carfax or other history reports for any car you're considering. Dealers often provide them for free. And be sure to ask the dealer for the car's completed CPO inspection report and an assurance that the car has no pending recalls. Excuse me. All right. I apologize. That will conclude our literary and jury charge practice.